there is an emphasis on trying to modify the homeowner's loan. So what happens is there's an analysis, preliminary analysis done by typically it could either be the court attorney or a hearing officer that's in the court part, and essentially it's tracked to try to determine whether or not this homeowner qualifies for, number one, the HAMP program, which is the Making Homes Affordable program instituted by President Obama, or whether or not the homeowner is eligible for a in-house loan modification that that particular plaintiff, institutional lender, has at their disposal. Now, participation in the Obama HAMP program is voluntary, and not all banks participate in that program. However, they're still required by law to at least go through the foreclosure settlement conference part. And if a homeowner does meet the income guidelines, and it is the homeowner's primary residence, then the case stays in the foreclosure settlement conference part until there is a determination as to whether or not the homeowner can qualify and or is eligible for a loan modification. And if the homeowner is eligible for a loan modification, there's back and forth, various submission of a homeowner's financial information for the past several years, and various other financial-related documents to qualify for a loan modification. That, in and of itself, depending on the county in which the foreclosure action is pending, that could be quite time-consuming. It's not uncommon at all for cases to languish in the foreclosure settlement conference part for up to a year. Within that time, depending on how the client wants to proceed, that certainly enables the homeowner to satisfy some of their other delinquent debts, get back on their feet, and hopefully save enough money so that they can be in a position moving forward to maintain and afford a sustainable and affordable loan modification. If a homeowner is not able to get a loan modification, then the case is sent out from the foreclosure settlement conference part to the foreclosure part. At the foreclosure conference part, all the legal issues that were raised in the answer, counterclaims and defenses that are raised are addressed at in the foreclosure part. Oftentimes, depending on the issues in the case, the banks are very reluctant to have a case go forward from the foreclosure settlement conference part if, after review of the case, they realize that there are significant legal issues that they need to address that perhaps upon review by a judge in the foreclosure part would certainly render them at risk in terms of actually having the ability to even bring the case forward. Once the case is sent to the foreclosure part, all the legal issues are addressed. All the legal issues that were raised by the defense attorney regarding the note itself, whether or not there was personal jurisdiction over the homeowner, whether or not the bank actually has the legal capacity to sue, whether or not there was violations at the closing of various federal and state laws, including RESPA, TILA, New York State's General Obligations Law. All of those issues are addressed at the foreclosure part. The bank will file a motion for summary judgment stating that there are no tribal issues of fact. That motion by the bank can be overcome if it is clearly proven that there are issues of consequence, meritorious issues, that if raised, the bank will file a motion for summary judgment, seeking to dismiss the arguments raised by defense counsel. Thereafter, a decision is made. A decision is either made in favor of the plaintiff, which is the bank, or it is made, obviously, in favor of the homeowner. Now, if the decision is made in favor of the bank would then move for an order of reference. An order of reference is simply a computation of all the fees associated with a foreclosure sale. Now, the bank would also do that in instances if there is no defense and if there has never been an answer filed in the action. After the order of reference, the case is put on the docket for a foreclosure sale, 30 days thereafter. At the auction, either a third party purchases title to the property, or the bank reacquires title to the property via a purchase as well. At that point, the right of redemption ends. But as I stated earlier, even if the bank has gone through this entire process where the homeowner, for whatever reason, simply never even responded and waited until after their home was actually sold at a foreclosure sale, that there was an occurrence of fraud, mistake, or collusion, then the homeowner, even at that very late stage, has a legal right to reacquire title to their property. So as I stated in the beginning, it's not hopeless. If you're willing to fight, so am I. And I conduct a forensic analysis of each and every foreclosure case that I'm retained on. Only then can I be informed as to whether or not your particular set of facts and circumstances fall within some of the guidelines that I previously mentioned that would enable me to zealously fight on your behalf to save your home.